We're tremendously saddened by Judge Pallmeyer's cold, heartless decision just 7 days after my mom has been told she's dying and given 3 to 6 months to live. We feel it is heartless and cruel.
That is the son of George and Lura Lynn Ryan condemning a judge's decision to keep his father, the former Illinois governor, in prison while his mother is dying. Ryan has served less than half of his sentence for corruption.
Attorney Thomas Glasgow joins us now this morning for a closer look at both sides of the argument and the decision as well. Always good to have you with us to walk us through these things. Now, the judges, former Governor Ryan's attorneys were arguing that part of his sentence was based on the honest services statute, which has been thrown out. Therefore, it should impact Judge Pallmeyer's decision. What do you think?
That's correct. Essentially, what they were attempting to do was to have the judge reconsider the sentencing or reconsider the actual convictions based on the ruling in Skilling, which said that the honest services statute was invalidated, but it was only invalidated by the Supreme Court for certain purposes. But it includes specifically bribes and kickbacks. Okay. Now, when we look at Judge Pallmeyer's her order, the 58-page order, all but 2 pages of it are devoted to what she did and how she came to the conclusion that he violated the mail fraud statute and the honest services statute by way of bribes, kickbacks, personal gains, his interactions with the co-defendants, the fact that he took steps to hide this through the tax evasion, through the lying to the FBI, which are some of the things that were not addressed during the course of the arguments, and that is he was also convicted of tax evasion. He was also convicted of lying to the FBI. He's doing 36 months and 60 months accordingly for both of those charges, in addition to the honest services statute. But essentially, the honest service statute is upheld for things of bribes and kickbacks. It's a differentiation between personal dealing.
Now, Thomas, you heard that very emotional plea from the family and the reaction after her decision. And some in the legal community have said, well, it's not fair to just single him out because of their emotional burden. What is your take on that?
The judge addressed that specifically in her order, and she said very succinctly that she does not taking away anyone's liberty lightly. And she was very caring and compassionate in her order, and that she understands the plight. She took into account the fact that these two have been very devoted to each other over the years, and she doesn't like the fact that she has to do what she has to do, but the law commands that she keep this person in jail. And if you were to treat Mr. Ryan specially, then there are others that she mentioned in her order that have more compelling circumstances that would have to be released as well.
Very quickly before we go, what do you think the likelihood of these other options, presidential clemency and the supervised probation to let him go home to see his family?
I believe they had already gone down the presidential clemency route once before. There is a provision under the code that they can ask or petition the Bureau of Prisons for a supervised leave. The family would be responsible for that, the cost of that. It's only in emergency situations. It's only for specific family emergencies that take into account the criminal background, the likelihood of recidivism, and whether or not an undue amount of press will be generated if the person is released. Those are part of the guidelines.
Wow.
So that's something that they're going to consider in releasing him or not releasing him.
Okay. As always, we appreciate it, sir.
Appreciate the
Merry Christmas to both of you guys.
Thank you.
Take care.
We'll be right back.